Hello, friends. I'm Amol, and I hope that all of you are doing well and keeping safe. In today's episode of Sunday Boosters, we will discuss the liquidated damages or Ascertained Damages Clause. The context would obviously be the commercial contracts and the provisions or relevant provisions of Section 74 of the Indian Contract Act 1872. Friends, in episode 4 of this series, while dealing with the confidentiality and non disclosure clause, I had briefly touched upon the concept of liquidated damages. And I had also mentioned that we'll discuss this clause in some other episode. The term liquidated damages in general, or as we all say in a layman's term, can be defined as follows: the damages which are pre-decided and defined by the parties to a contract at the time of conceptualization and drafting of the contract itself, and typically quantify either the amount or the mechanism to ascertain the quantum of damages which are supposed to be paid to the affected party in case of a breach of the contract. In a commercial contract, the liquidated damages clause may make a lot of sense as it can provide quite a few advantages. What are those advantages? First, parties are aware of the extent to which they can be exposed to damages claim in case of a breach, and thus it works as a deterrent for breach, or it gives a fair idea of the quantum of damages and also creates a situation where the parties may not be required to prove actual extent of the damages. And C, since the burden to prove actual losses is much lesser as compared to any other commercial contract without liquidated damages clause, the same may prove to be a time and resource saving tool in contract. Having said this, it is essential to understand the legal position around the liquidated damages clause so that while drafting or vetting a commercial contract, no ambiguities are left by the parties. Now let us consider the statutory provisions under which the concept of liquidated damages finds place and mention. Provisions of Section 74 of the Indian Contract Act read as follows: when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of breach is entitled, whether or not actual damages or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty stipulated for. To simplify this provision, let us take out some of the important phrases from this clause. The first phrase is the sum has to be named in the contract, meaning you have to specifically mention the quantum or the sum to be awarded as liquidated damages. B, it has to be mentioned as an amount to be paid in case of a breach. C, to whom it is to be paid? The party who complains of a breach. D, whether or not actual damages or loss is proved to have been caused. E, receive from the party who has broken the contract. And F, amount not exceeding the amount so named. So what do you think? If a liquidated damages clause is in a contract specifies an amount to be paid to the affected party in case of a breach, does that mean that the affected party can simply issue a notice of claim and get the amount quantified? The answer is plain and simple no. There are several precedences around the subject where the courts have laid down the law and rules around liquidated damages. We will not discuss the cases and precedences here, but the following summary of rules will come handy for you to know as to what goes behind claiming and establishing a civil claim for liquidated damages. The rules that are laid down by the court can be summarized in the following points. First rule is an affected party still has to issue notice and lodge a claim for liquidated damages. That's the first rule. So it will not come to you automatically. You have to still issue notices, lodge a claim, and claim liquidated damages. Two, and obviously I'm talking about this when a contract includes liquidated damages clause. Two, the affected party still has to establish the breach of contract. Without establishing, you cannot claim liquidated damages. Three, the affected party also needs to prove that the breach is of such a nature that it attracts liquidated damages clause under the contract. So not any breach of the contract will attract liquidated damages unless it is defined to be so. And fourth, even when the section does not require a party to prove exact nature and quantum of damages, the courts do apply the rationale of actual damages and reasonableness. That is to say, if in a case, for example, a party is not able to prove that the maximum extent of liquidated damages can be claimed, the court will apply reasonability principle. If in a case a party is not able to prove breach at all, court will not grant the liquidated damages, so on and so forth. It is therefore very important for the parties to frame a draft which covers the following aspects in an unambiguous and clear language while drafting a commercial contract. First important point is what all breaches are covered by liquidated damages. Clearly specify as to what are all those breaches that you want to cover through this liquidated damages clause. Don't keep the language generic. B. Capture the rationale on which the liquidated damages is based. So try and define as to how have you actually arrived at this amount, so that reasonability is explained clearly in the contract itself and the courts have to work that much lesser. And third, mention exact quantum or provide a clear and unambiguous formula for calculation of liquidated damages. I'm sure if the above issues are taken care of, you will have a winner in the liquidated damages clause and will be saved from a lot of documentation, evidence, and time at the time of breach of a contract. I hope you liked the episode. Just search for Lex Prudence, spelled as LEX-PRUDENCE on your favorite podcast platform. That is Anchor, Spotify, Google Podcast, Breaker, or Radio Public. And listen. Needless to say, please subscribe and share also. And don't forget to send in your comments and feedback. Have a great day and take good care of yourself. Goodbye.